All right, everybody, welcome. Justice is the Process is here, and we are live, and got a couple things to talk about tonight. I was going to go live earlier, but some things came up, and then I wasn't even going to go live at all, and then I'm cutting some shorts and, you know, run into this issue with the Crumbley case. And man, oh man, do we have something to talk about in regards to the Crumbley case. It's huge. It's going to get the it could very well lead to the Crumbley verdicts being reversed. Of course, there's other issues, but there's a major issue that just came out. We're going to talk about it. How you doing, Ian? But first off, let's deal with the biggest news that we have, and we're still watching the trial. So I hope um, I don't ruin the outcome. But we're in the middle of day 6. I stopped day 6 in the middle. And we're going to resume the post-lunch session tomorrow for day 6, and then hopefully knock out day 7, 8, and hopefully 9, and then we'll get closing arguments, and then watch the trial together as part of our series to end and get an official day 11 in. But we have a verdict in the Daniel Howard case, so we're going to first watch that verdict. Then we will get into the Crumbley information. Then we're going to talk about some things in relationship to the Crumbley information. And then we're going to call it a night. It's going to be a short one. We're not going to be watching long videos. But the Crumbley stuff is absolutely crazy. And it's upsetting. And it just shows how corrupt Karen McDonald is and how she was willing to break laws, do anything to get the verdict. Yeah, expected verdict, 8 hours of deliberation was surprising. Especially after I got done watching today's testimony. I'm shocked it took him 8 hours because to me, the physical evidence was just overwhelming, and the fact that the things he did, the way he was treating her, uh, the various different things he'd done leading up to this thing, and then you couple that with the physical evidence, the fact that the tongue didn't bleed like it was, because clearly there was no blood running through her body at the time that she was shot. The way the mouth was open and there was no damage to the teeth, the burns, the physical. I mean, once you get through all these witnesses, it was like, I understand why people might have thought he was running on Friday, although I don't think he was. But if I was him, I would have I would have probably ran, because I mean, it looked like it didn't take a rocket scientist to look at the evidence that had been presented and think this jury's going to convict this man. And now he faces 10 years to life. But anyways, we'll talk about all that here once we get done watching the verdict, but let's get in here and watch the verdict first. Give me a moment. All right, so let's turn our TV on. There we have it. Get this thing queued up in here, and courtesy of Law and Crime, they will be bringing us our verdict coverage tonight. Let's take a look at this.
You may be seated. Members of the jury, I'll ask you to speak through your foreperson. Who is that? All right, have you in fact reached a verdict?
Yes, I have.
All right, if you would hand the verdict form to my bailiff, please.
Ian, the difference is premeditation, believe it or not. And in this case, it's clear there was premeditation. So why they went second, I have no idea.
Of the state of Idaho, in and for the county of Kootenai, state of Idaho versus Daniel C. Howard. We, the jury, duly impaneled and sworn to the above entitled action for our verdict, unanimously answer the questions submitted to us as follows. Count 1, is the defendant Daniel C. Howard guilty or not guilty of domestic battery? Guilty. Count 2, is the defendant Daniel C. Howard guilty or not guilty of
And
murder?
for a minute, I thought they split here. I was like, holy cow.
Is the defendant
Then I realized they had a lesser
Daniel
included.
Howard guilty or not guilty of second-degree murder? Guilty.
And I'll note it's signed by the presiding officer. Members of the
And
jury.
even though he's in custody, the judge dramatically made the jury believe he was being remanded.
Do either of the attorneys wish to have the jury polled? Members of the jury, I'll tell you what happens next. I'll set this matter for sentencing. Mr. Howard is remanded into custody. Counsel, I'm proposing a sentencing date of May 23rd at 1:30 p.m. That's available. I will order a PSI or a pre-sentence investigation. Mr. Howard, I'll have you talk with your attorney about that. You have the right to participate or not participate in that. You continue to have the right to remain silent. Members of the jury, I'm going to read you a closing instruction. I'm giving you a lot of instructions during this case. You have now completed your duties as jurors in this case and are discharged with the sincere thanks of the court. The question may arise as to whether you may discuss this case with the attorneys or with anyone else.
It's actually 30 days in
The
jail.
court instructs you that
For the
whether
first
you talk to
one,
the
for the first
attorneys or to anyone else is entirely your own decision.
So that's why I thought, oh, they found him guilty of that, and they were going to let him go on
But you
the
are not required to do so.
worst
And you may
charge.
choose not to
And of
discuss
course,
the
they don't
case
get to
with
consider
anyone
the
at
sentence.
all. If you choose to, you may tell them as much or as little as you like, but you should be careful to respect the privacy and feelings of your fellow jurors. Remember that they understood their deliberations to be confidential. Therefore, you should limit your comments to your own perceptions and feelings. If anyone persists in discussing the case over your objection or becomes critical of your service, either before or after any discussion has begun, please report it back to me. And with that, I want to thank you for your patience, for your attentiveness, your conscientiousness and attention to detail throughout this case, and the time that you gave in service to this case. I thank the attorneys again for their professionalism and excellent advocacy. All right, I will excuse the jury at this time, and please stand for the jury.
And now we get to watch the fun part when he gets let out of the courtroom in cuffs. And watch as he realizes his life is over as he knows it.
All right, Mr. Howard is remanded into custody. I'll see everyone back May 23rd at 1:30 for sentencing. We will be in recess. I'm going to break. Okay.
All right, so we got that out of the way. The verdict is in. So my opinion on that verdict, the jury got this thing right. It was the right verdict. And Ian, you're correct. He faces a minimum of 10 years to life. Now the judge can impose any sentence, any minimum that they want. So what's going to be now? An interesting thing is if he would have been convicted of first degree, he still would have faced a minimum of 10 years to life. So it is The difference between first and second degree in this case is merely facts. The judge will have the ability, based on the pre-sentence investigation, to decide. He could say 25 years, 30 years, 40 years. He gets to decide based on the set of facts, based on the evidence he heard in the case. The jury obviously made a finding here that it wasn't premeditated. I guess here's what the jury found. This is essentially what the jury found. Is their belief was the state had gone out of its way. And again, I haven't seen what the defense put on, and I didn't hear the defense. I peeked in a little bit on the defense's closing, but without hearing all the evidence, I couldn't appreciate it. But it appears what the jury felt happened here is that this man lost control. He's dealing with the fact that his wife's going to leave him. He's found out that she's having an affair, and he does the carotid chokehold, and essentially, in their opinion, grabs her and kills her, right? Grabs her around her neck, just like they said could happen. They said the carotid choke would essentially not cause petechial hemorrhaging, not cause any of that, any of the things you would see on a strangulation, and kills her. And now he's got a problem. Oh my God. So he covers it up by putting her in the bathtub and gets a gun out and makes it look like a suicide. And that's what they concluded in that jury room. So they didn't charge him with any of the things he did after the fact. They charged him, in this case, they said it was in, a passion, heat of passion. He kills her, boom, and that's it. No premeditation. But in the moment, it wasn't premeditated from the standpoint he didn't plan to do this. It was just in the moment, in a split second, he says, I'm going to kill her, and boom, does. So it was intentional. It was an intentional act with the intent to kill, with malice. So that's why they did what they did here. Now, again, I haven't had the benefit of hearing this entire trial, but after today, I think for them, that was the debate they had for 8 hours. Some wanted to go first, others wanted to go second. It is going to make a difference to the judge, because the fact that the jury finds that this wasn't a thought out plan, the judge has to respect that. And he can't just run off and sentence him differently than what the jury found. What the jury found in this case, that's what the judge is going to be bound by. Now, that doesn't mean the state can't. That's why the state hasn't made a recommendation. There was a news report that I listened to that said the state has decided they're going to wait on listening to the pre-trial motions. So, looking forward to getting deeper into this case and learning more about what the evidence is as we proceed. But let's move on to the main event here. We're going to waste no time getting into this. So we're going to introduce this. This is some crazy stuff. Then we're going to get into the analysis, and we're going to be jumping between the document review room and the justice camp. But anyways, let's fire up the justice camp and get back into the justice room here. Give me one moment. All right, so let me find this video here. All right, I've got it. So the first thing we're going to do, I figure what we'll do is we're going to listen to the defense attorney. And actually, you know what? We're going to introduce the corruption first. So let's listen to this here. This is Karen McDonald. Interview she just did today, and in this interview it comes out that the two school officials that testified, had what they call proffer agreements that basically said, if you testify, we will agree not to use anything you're testifying about against you. And essentially they agreed that based on what they proffered, they wouldn't prosecute. Now, the state is trying to say, well, that it's not significant because we didn't tell them we wouldn't prosecute them. We just told them we wouldn't use what they were saying. But this was never disclosed to the defense. This was never disclosed, and there's an issue here. We're going to talk about a case, Giglio versus the United States, and it becomes a potential violation. It could even be considered a Brady violation, but this is going to be Giglio versus the United States holds that. We're going to talk about the case, but I believe appellate attorney this falls right in line with that case, and in that case, the prosecutor withheld information that the United States Attorney's Office had agreed not to prosecute. And in this case, these two gentlemen's testimony was material, number one. Number two, they offered opinions. Very importantly, offered opinions. And the appearance to the jury was that they were just offering their own opinions with no influence. Well, there's definite influence when they're sitting there knowing that the state has already said that what they did was criminal and they're trying to avoid being prosecuted. So therefore, the jury should have known that there was an influence on the opinions they were expressing, especially since they were expressing in the jury. One of the two key factors was the duty of care originating from what they saw in that office. And had the jury known that the state was choosing to not prosecute those two, and that those two guys were in there trying to avoid being prosecuted, and they had an agreement that nothing they were saying was going to be used to be prosecuted against them, thereby they could say whatever they wanted, and thereby they were essentially being assessed by the state, and they knew that if the state decides, I don't like what you said in this case, they could go off and prosecute them. And they certainly wouldn't need anything that they said on the stand to do that, because they already would have known that, based on the emails and everything else, that in statements they made to the police, they could have prosecuted them already. But the reason why they didn't get prosecuted, the reason why they're sitting at home and the Crumbleys are sitting in jail, and the reason why we've all been sitting here saying, why did the school officials not get taken to prosecuted here? And the reason is because they made an agreement with them not to do so. And when an appeals court gets hold of this, that is a due process issue. The due process rights of the Crumleys have been violated left and right in this case. They were violated in the fact that they created a law, that they carved out a law that didn't exist. They created a way for the manslaughter law to be violated after the fact. It was vague and should have been voided. The interpretation of that law by the appeals court was vague, violating the due process law or due process rights of the Crumleys. And then on top of that, they withheld the presence of these proffer agreements, and they were not allowed to be cross-examined. And these prosecutors are corrupt as shit, man. They are corrupt as hell. And Karen McDonald did this because she wanted to become governor. She did it for political purposes. She's a corrupt individual, and she thinks that simply because she has a righteous cause that it will forgive her corruption, and righteousness never forgives corruption, because you are just as bad as them. You are just as bad as the people you're prosecuting when you're doing these things. And the way you've attempted to use the law, the appeals court needs to come down on her and come down on her hard and reverse this case. But it won't reverse the hell that the Crumleys have been through with the way they went after them. Because the real people in this, I mean, can you imagine this? The only reason why the school was saying, the only reason why we're viewing the Crumleys as the bad guys in a sense is because that school. Well, yes, but he threatened her in the sense that he said he was going to try to make her life hell. He's threatening her because, I mean, how would you feel if you're finding out here this woman is coming after you and trying to go after you politically? She's twisting and turning the laws, and then on top of that, you find out that she's withholding critical information about key witnesses in your case because she was out to get them. And I mean, threatening her was not the was not the right move. I don't believe that. I don't believe that makes that wasn't justified. But the bottom line is she's corrupt as hell. So, anyways, let's watch. We're going to go in. Let's turn the TV on and let's watch this interview here.
Us today at 5, I'm Glenda Lewis.
And I'm Brian Abel. Today, Karen McDonald addressed that and other new revelations since a guilty verdict came down from a second jury. Just last week, the shooter's father was found guilty on 4 counts of involuntary manslaughter. His wife found guilty on the exact same charges just last month.
And today and every day, we remember and honor the lives of Tate Meir, Madison Baldwin, Hannah St. Juliana, and Justin Schilling.
7 Action News reporter Simon Shaquette shows us what more unfolded behind the scenes of the historic trial involving the first parents charged in a school mass shooting.
Today, Karen McDonald talking about her case and a guilty verdict against James Crumbley, the father of the Oxford High School shooter. She's also talking about letters given to 2 key witnesses and threats made against her.
I'm not going to let anything stop me from prosecuting and advocating for victims.
In a sit-down interview covering a range
including
of
the law,
2 separate jury trials and guilty verdicts against James and Jennifer Crumbley, prosecutor Karen McDonald opening up about what's taken place since the deadly school shooting at Oxford High in November 2021. Both parents convicted of involuntary manslaughter for failing to secure a gun used by their son and to give ordinary care to get him help, resulting in the deaths of 4 students and others wounded.
It's about those victims. It's about those kids.
In court, McDonald personally demonstrated just one of the safeguards parents could have used but didn't.
I'm not an expert in firearms, but it took me around 10 seconds to apply the cable lock.
Since the end of trial, McDonald has confirmed threats made by James Crumbley from jail were directed at her. And while she stopped short of publicly releasing them, I asked and was granted a chance to hear them off camera. Crumbley stating he was coming for the prosecutor and referencing her going to hell.
He actually said that. He hoped I was listening. He hoped I was listening when he threatened me physically. One of the most disturbing threats was January of 24. So that was actually the same month that the first day of trial was set for.
Professor of Law at University of Detroit Mercy and former federal prosecutor Adam Wright, also adding this to steps taken to keep everyone safe in court.
The way that Karen McDonald handled this was exactly the right way. Sheriff's Office handled this situation exactly as it should have been handled.
In court, prosecutors asked for a court order limiting Crumbley to only communicating with his attorney. Also, I asked McDonald about letters given to a counselor and a dean of students who gave key testimony.
Is there any agreement in place with anyone that they will not be prosecuted?
You know, the media reports or anyone reporting that there was some agreement, they're just absolutely false. We comply with the court rules and the case law to a T. The only thing required to give to the defense, and rightly so, I stand by that, I insist that our assistant prosecutors do that, is any agreement we've made with a witness that gives them a plea deal or immunity in exchange for their testimony under oath to prove our case. That was not done.
I also asked and verified that with the counselor's attorney.
There's nothing in the proffer agreement that says that the person providing the proffer will not be prosecuted.
Does a prosecutor have a duty to disclose to the criminal defense that a proffer letter was provided to your client?
No. If there was an immunity agreement, yes, but a proffer letter, no.
As for how this case could spark more change, McDonald says she's not done supporting the Oxford families, but wants families across the country to know.
Most of us do not need to be told that if you're called to the school and you see, help me, blood everywhere, the world is ending with a gun drawn that precisely matches the gun that you had just purchased for your troubled son, and you never tell them that you did it, and then when asked to get him help, you just leave. Most of us don't need a message like that.
We have filed a Freedom of Information Act request for recordings of those threats and copies of the letters given to those key witnesses. It is currently being reviewed. From Pontiac, Simon Shaquette, 7 Action News.
And the defense attorney for the father of the shooter is responding to the alleged threats. In a statement, Marielle Lehman says, quote, "We continue to disagree with the prosecution's characterization of the phone conversations with James and decline further comments."
And as we speak of the father's defense attorney, 7 investigator Heather Catallo sitting down with her tonight on Action News at 6.
Why she says he did not take the stand, and hear her message to the Oxford community. That's all.
So there we have it. Now, I'm going to show you a case, and we're going to talk about this case, and we're going to talk about that. What Karen McDonald said, I don't believe is going to hold up. I think that she's incorrect. I think she's looking at this incorrectly, and I think that she is hoping that the appeals court is going to say that the information wouldn't have changed the outcome. So she was basically saying, let's get the conviction and then worry about it later. And then hope that the appeals court wouldn't have the courage to overturn that conviction because of political pressure. She is incorrect. That proffer agreement goes directly to the credibility of the witnesses, and I believe it's a Giglio. It fits right in with I don't know if it's pronounced Giglio or Giglio, but Giglio, I believe it would fit right in with that case, and we're going to read that case here in just a moment. So let's fire that case up here and read it together. And chat, you tell me what you think as we go through this case. So give me a moment here. Let me pull that case up. All right, make sure this thing is in. Okay, so this is the case. It's called Giglio versus the United States. So we're going to read through it and look at this. So first off, the syllabus tells us what the case is about. So petitioner filed a motion for a new trial on the basis of newly discovered evidence contending that the government failed to disclose an alleged promise of leniency made to its key witness in return for his testimony. At a hearing on this motion, the assistant United States attorney who presented the case to the grand jury admitted that he promised the witness that he would not be prosecuted if he testified before the grand jury and at trial. The assistant who tried the case was unaware of the promise. Neither the assistant's lack of authority nor his failure to inform his superiors and associates is controlling, and the prosecution's duty to present all material evidence to the jury was not fulfilled and constitutes a violation of due process requiring a new trial. So essentially here, what I'm asserting is that the circumstances in this case, and that is that you have an agreement that would have influence over the testimony, such as a proffer agreement, that they're agreeing not to use the information contained in the testimony of those two individuals, and they agree not to use that as evidence, the jury should have been aware of that. Now, as you're going to see here, there's nothing here that says conclusively that it only deals with prosecution or a immunity, or that it has to say we won't prosecute you at all. I think it could be inferred, as that defense attorney said, that they looked at the facts of the case and said, well, we're not going to prosecute. Well, why would the state say they're not going to prosecute? Because they claim they didn't know that the gun was purchased 4 days before, which is garbage. That's ridiculous. But it certainly should have been known that they were offering to these two gentlemen. Why would they need a proffer agreement to testify if the state didn't look at what they did as illegal? And if the state was potentially looking at what they did as illegal, the jury should have known that, because that would be pressuring these individuals to try to offset the blame onto the Crumbleys. And it was important, basically by inference, that the state would be saying to these two gentlemen, to these two gentlemen that apologize there, that the state would be saying by inference to these two gentlemen, hey, if you do not, if you don't testify that it was the Crumbley's fault, that it was the Crumleys who came in, this would explain exactly why they would be saying, well, when the Crumleys came in, Mrs. Crumbley was ready to, trying to leave, and Mr. Crumbley was an uncaring parent, and they didn't show adequate care because they knew that if they testified any different than that, and that would have been an absolute area that the defense should have gone in to show they had a motivation to lie, because they were going to potentially face prosecution, and that they were testifying, and it was important that if they left it unsaid, in other words, if they didn't come in and testify, then the prosecution could come in and would go ahead and fill in the blanks for them and say, you know what, we're going to prosecute you. And they've already shown it. I mean, they prosecute Ethan Crumbley under a theory that he's the worst criminal known to mankind with no mental illness. They prosecute the parents saying that he has a mental illness that they should have identified, and that they came into the school, didn't care, were uncaring parents, which is absolutely ludicrous. And James Crumbley appeared to be a very caring father who was spending time with his son, taking him to the shooting range as a bonding experience, and appeared to have no known idea that his son was having mental problems at all, and that there was some major mental issue. He's taking him to school the day of this thing happening and saying, listen, we just want you to get good grades. We just want you to follow through on your responsibilities. And then you get the shooting range back. You get full access to your phone back. Your life will be good again, son. Does that sound like a guy who's sitting here going, yeah, I'm just comfortable with my son going in and shooting up a school? Does it sound like a guy who thinks his son has a gun in his book bag and is about to shoot up a school? No. Just like those two guys that are sitting in that school. And why are they painting the Crumbleys in such a bad light? Because they have to. And that agreement shows that. Anyways, but let's get back to the case at hand here and see how we interpret this, right? We're not lawyers, so we're going to interpret it ourselves. But I believe a lawyer, a good appellate attorney, should be able to take this case and apply this case to it, and potentially others. I don't have the ability to see other sites, but I would imagine there's got to be other cases, and I haven't had the time. I'm going to try to do some research myself to see if I can find other cases that might be close enough or might deal with proffer agreements or agreements to not use testimony, and see what other courts have said. But petitioner was convicted of passing forged money orders and sentenced to 5 years imprisonment. While appeal was pending in the Court of Appeals, defense counsel discovered new evidence indicating that the government had failed to disclose an alleged promise made to its key witness that he would not be prosecuted if he testified for the government. We granted certiorari to determine whether the evidence not disclosed was such as to require a new trial under the due process criteria of Napu v. Illinois and Brady v. Maryland. The controversy in this case centers around the testimony of Robert Taliento, petitioner's alleged co-conspirator in the offense, and the only witness linking petitioner with the crime. The government's evidence at trial showed that in June 1966, officials at the Manufacturers Hanover Trust discovered that Taliento, as teller at the bank, had cashed several forged money orders. Upon questioning by the FBI agents, he confessed supplying petitioner with one of the bank customers' signature cards used by Giglio to forge 2,300 in money orders. Taliento then processed these money orders through the regular channels of the bank. Taliento related this story to the grand jury, and petitioner was indicted. Thereafter, he was named as a co-conspirator with the petitioner, but was not indicted. Trial commenced 2 years after indictment, and Taliento testified, identifying Upon questioning by FBI agents, Taliento then hold on a minute, where was I at here? Oh, there it is. Defense. So trial commenced 2 years after indictment, and Taliento testified, identifying petitioner as the investigator of the scheme. Defense counsel vigorously cross-examined, seeking to discredit his testimony by revealing possible agreements or arrangements for prosecutorial leniency. Did anybody tell you at any time that if you implicated somebody else in this case that you yourself would not be prosecuted? Nobody told me I wouldn't be prosecuted. Question. They told you might not be prosecuted? A. I believe I still could be prosecuted. Question. Were you ever arrested in this case or charged with anything in connection with these money orders that you testified to? A. Not at that particular time. Question. To this date, have you been charged with any crime? Answer. Not that I know of, unless they are still going to prosecute. In summation, the government attorney stated Taliento received no promises that he would not be indicted. The issue now before the court arose on petitioner's motion for a new trial on newly discovered evidence. An affidavit filed by the government as part of its opposition to a new trial confirms petitioner's claim that a promise was made to Taliento by one assistant to Paola that if he testified before the grand jury and at trial, he would not be prosecuted. Di Paola presented the government's case to the grand jury, but did not try the case in the district court. And Golden, the assistant who took over the case for trial, filed an affidavit stating that Di Paola assured him before the trial that no promises of immunity had been made to Taliento. State's attorney Hoey filed an affidavit stating that he had personally consulted with Taliento and his attorney shortly before trial to emphasize that Taliento would definitely be prosecuted if he did not testify, and that if he did testify, he would be obliged to rely on the good judgment and conscience of the government as to whether he would be prosecuted. The district attorney did not undertake to resolve the apparent conflict between the two assistant United States attorneys, Di Paola and Golden, but proceeded on the theory that even if a promise had been made by Di Paola, it was not authorized, and its disclosure to the jury would not have affected its verdict. We need not concern ourselves with the differing versions of events as described by the two assistants in their affidavits. The heart of the matter is that one assistant United States attorney, the first one who dealt with Taliento, now states that he promised Taliento that he would not be prosecuted if he cooperated with the government. As long ago as Mooney versus Holohan, this court made clear that deliberate deception of a court and jurors by the presentation of known false evidence is incompatible with rudimentary demands of justice. This was reaffirmed in Pyle v. Kansas. In Nepu versus Illinois, we said that the same result obtains when the state, although not soliciting false evidence, allows it to go uncorrected when it appears. Thereafter, Brady v. Maryland held that suppression of material evidence justifies a new trial, irrespective of the good faith or bad faith of the prosecution. All right. So essentially here, guys, what we can take from this is in this case, you have a situation where the prosecution, obviously there was discussions about, and again, this is where Karen McDonald's going to make the distinction to say that there wasn't a promise here to not prosecute, that it was just a promise to not use the information. However, in my opinion, the issue here at hand is the fact that this goes to the credibility of the witness and the materiality of the evidence. When you look at the fact that these two gentlemen could almost be considered in terms of an involuntary manslaughter as co-conspirators. I mean, these guys are all sitting there allegedly conspiring to allow Ethan Crumbley back to class, even though they all have knowledge that he's been at a gun range, he has an interest in guns. He obviously, the fact that he was at a gun range means that they could infer, these two gentlemen could have inferred that he had the ability and access to get to a gun, and they did nothing. And these gentlemen know that if they don't testify, then the state, why do they need their attorneys intervening here? Why do they need a proffer agreement? The reason is is because they were worried they were going to get prosecuted. So they were told, this is what you need to say. And they proffered what they were willing to say. And the state says, we won't use that against you. And essentially, they get the go ahead that based on what they were being told by these witnesses, that if that was the story they present to the jury, no prosecution would come at any point. So in my opinion, when you read down through this case, I understand why Karen McDonald may feel like, well, in this case here, it deals specifically with, uh, it deals specifically with uh, an alleged agreement that said we won't prosecute you, or at least one of the attorneys won't prosecute you. However, in my opinion, I think if you take pieces of this case and then you take the idea in Brady, that you have the idea here that there is a due process violation from the standpoint of the defendant has a right to confront these witnesses. The defendant has a right to understand what might be influencing the testimony of these witnesses. And when a prosecutor has knowledge of an agreement that might be impacting the willingness or the credibility of this witness, they have a right to disclose that, or they have a requirement to disclose that to the defense so that the jury can hear this. And the fact that they knowingly withheld this from the jury, in my opinion, and this would be an opportunity for a good appellate attorney to enlarge the footprint of this case and say, listen, we're expanding it to say, it's not just an agreement to prosecute. It's any agreement where a prosecutor is able to influence the credibility of a witness or the credibility of testimony. Essentially, in this case, it was an understood situation here. We will prosecute you if we believe that, in the case of a manslaughter case, those men would have been prosecuted if they wouldn't have been testifying against the Crumbleys. But because McDonald wanted the Crumbleys, she was willing to let those two guys off by justifying it as, well, they didn't have they didn't have the knowledge that the gun was bought 4 days before. That's really irrelevant. They saw the same sheet. Everything that Karen McDonald said in that interview, those gentlemen saw. So the idea that she would say they're less responsible than the Crumleys is ridiculous. It's absolutely ridiculous. But the idea that you would say that their testimony didn't influence those jurors or didn't influence the outcome, you can't say that, because it very much did. They literally sat in that courtroom as trained professionals, trained counselors, saying, in our opinion, based on our experience and knowledge of how parents have interacted with their kids, the Crumleys were cold, uncaring parents. And that went unimpeached. And there was and the way it stood before the jury was, well, these guys are just offering this as concerned administrators. And it was like, well, what is there any reason why they would offer that up? No. Well, there was. And that was the fact that they had entered into a proffer agreement, which thereby shows that there was a possibility of prosecution going on, and that possibility of prosecution went out the window when the proffer agreement comes into effect that states, we will not use this testimony against you, whatever you say. So it's like, why would that matter, and why would that need to be done? Let the jury consider that. Let the jury consider what all of that means. Let them be questioned about what it was they agreed, why they felt the need for a proffer agreement. That should all be able to come in to that jury, 110%. And the fact that it was blocked. Well, Ian, I think they will, because, I don't think they're going to get a light sentence. I think they're going to get the maximum sentence. I think that they're going to get the maximum sentence the guidelines allow. Remember, 4 children lost their life. This judge is not going to just ignore that. And Karen McDonald and her crazy bunch of prosecutors are going to come in here ready to burn them at the stake. That's just the way she is. So I apologize. Sorry about that. I apologize. I didn't realize I hit the mute button. So I was just kind of scanning through the case to see if there's anything else we need to read on it. But I think we hit the high points on this case. But this case deals with the requirement of the state. And the test is for this to apply, in my opinion, is does it affect, does this agreement, first of all, would it have had a bearing on the outcome of the case? Yes. And two, did it have a bearing on the credibility of the witness? And that answer to that is yes. So as a result, in my opinion, this opens it up. On top of that, you would, you could also say, in a sense, it would almost fall under Brady as well, which says that there's exculpatory evidence that's allowed to come in, because what's in this case, if they were allowed to rely, in other words, so let's look at it like this. These guys offered potential exculpatory evidence for them, right? And that would have been, hey, we told the Crumbleys that they didn't need to take their son out. And we told the Crumbleys that based on our experience, that we believed the best place for him was school. That they came in, they were concerned, they showed up. And we looked at that paper and we didn't have any concerns. And Mr. Crumbley talked. Remember, the whole conversation between Mr. Crumbley and his son is documented by these witnesses. So to me, I think it's a situation where if you would say, well, these gentlemen have a proffer agreement that says, listen, we're agreeing not to use your testimony against you, and that was entered into and negotiated for, that shows that to me amounts to almost a no prosecution agreement. Again, like I said, a good appellate attorney here is needed. Whether or not they will, how this goes, of course, whether or not the appeals court will have the character and the willingness to stand up and do the right thing here and kick this out and hold this prosecution accountable, I don't know. Because again, one of the things that they can stand on here, one of the ways they could try to get around this is say, well, we never said we wouldn't prosecute them. We just said we wouldn't use the evidence in their testimony to prosecute them, which is double speak. We know what happened here. And I disagree that they didn't have to turn it over. Anyway, so the final thing we're going to look at here is going to be, give me a moment, we're going to go back into the video room here. All right, so let's fire this up. We're going to watch the second part of this where James Crumbley's attorney gets interviewed and she addresses these issues. We'll watch this, we'll react to that, and then we'll call it a night. But like I said, just the willingness of these prosecutors to just do these things with it's a win at all cost attitude. And to me, you got to follow the law. You got to be fair, and you should want everything to go before the jury so the jury can adequately assess a case. And in this case, they didn't want that. We know that because they didn't have a case. They didn't have a case unless they pulled bullshit. That's what they did in this case. But anyways, let's turn this on. Let's turn the TV on, and let's take a look at this.
James Crumbley speaking publicly for the first time since his conviction. Thank you for joining us tonight. I'm Carolyn Clifford.
And I'm Mike Duffy. Days after the guilty verdict, defense attorney Marielle Lehman is taking us inside the historic trial.
In her only sit-down interview with 7 investigator Heather Catallo, why she maintains James Crumbley did not do anything illegal, why she says he did not take the stand, and what she wants the Oxford community to know.
What is your message to the community and the victims' families?
I think I made it very clear during trial that I don't take this lightly at all. I know the loss that the families have experienced. I do feel terrible for those families. I feel horrible for the community. They have all experienced something that they can never forget, and losses that they can never get back.
Defense attorney Marielle Lehman says she hopes now that the jury has delivered a verdict, the Oxford community can start to heal. While Lehman says she doesn't agree with the jury's decision, she's made it her mission since she was hired by James Crumbley to fight his case in the courtroom and not in the court of public opinion. Now that the judge has lifted the gag order, Lehman agreed to answer some of our questions.
James feels terrible for what happened. He feels terrible for the families who lost their children, for the individuals who were directly affected by the shooting at Oxford High School. That's something that I don't know if people realize, but it's very true.
After 10 hours of deliberation last week, a jury of 6 men and 6 women found James Crumbley guilty of involuntary manslaughter.
Guilty of involuntary manslaughter.
His son was sentenced to life in prison after pleading guilty to terrorism and murder charges for killing Hannah St. Juliana, Tate Meir, Madison Baldwin, and Justin Schilling inside Oxford High School on November 30th, 2021.
That nightmare was preventable.
As the first parents to be found guilty of involuntary manslaughter in a mass school shooting, James and Jennifer Crumbley made history.
He wishes that he had made different decisions that day. Unfortunately, we can't go back. And looking in hindsight, maybe different decisions could have been made.
Law enforcement officers testified that James Crumbley purchased the 9mm semi-automatic pistol just days before the school shooting, and his 15-year-old boasted on social media, referring to the weapon as his own.
Where was the gun at? It was hidden in our arm, in the case. And the bullets were hidden in a completely different spot.
He failed to perform his legal duty to prevent these kids from being killed. And he failed their parents too.
What the jurors had to do was incredibly difficult. The things that they had to watch. I maintain that James did not do anything illegal in the storage of that firearm. In 2021, there were no laws regarding how that firearm is stored. There wasn't anything illegal about it. And James didn't know what his son could or would do. He didn't know that his son even knew where that firearm was.
James Crumbley's wife, Jennifer, took this.
Now, the thing that bothers me with what I wish she would have been more aggressive with when she was answering that is talking about the fact that his need to worry about where that firearm was, his need to protect the children of the school he had to first believe, and he had to have the reasonable foreseeability that this would even occur. It had to be foreseen that it would occur. And the fact, I know she addresses that there, but she really didn't, neither attorneys for these two parents adequately explained the way the law required this jury to find. And that was, they had to find a foreseeability factor first. That test had to happen first. And that test required them, regardless of whether Karen McDonald wanted them to see it or not. And as she sits there and talks about duty of care and all of this other stuff, none of that kicks in unless if it wasn't foreseeable, if they didn't have a reason to believe that this was going to happen, if they didn't have a reason to believe that their son was mentally having mental problems, if they didn't believe it. Now, clearly he was a disturbed individual. But if they didn't have that information in front of them, if they didn't know about it, if they weren't reading the journal, did they have an obligation to read the journal? Well, why would they? I mean, you don't have an obligation to just read your kid's journal unless you have an actual reason to. They believe their child was going through the normal stresses of childhood, and that he was having some issues. But that doesn't mean she needs to go through that. They needed to go through all the journals. If they're talking to him, they're having conversations with him. Clearly, this young man was fooling everybody. He was fooling the teachers. He was fooling the counselors. He was fooling everyone. Um, I agree, and so to me, I think that but the issue at hand to me with these attorneys was it seemed they just failed to understand how this law read, and to me, it was quite clear that just like I pointed out when we did the breakdown of the landmark decision that allowed this case to go forward, that the prime main test in this case was the foreseeability test. It had to be foreseeable. And Carrie McDonald didn't like that. She said, well, she tried to blur what that meant. But that's why the defense attorney needed to make them understand that, guess what? In this case, right? It is not the burden of the defense to prove it wasn't foreseeable. Okay? Or that it was foreseeable, I guess I should say. Or that it wasn't foreseeable. That was already presumed from day one. So again, I don't understand why these defense attorneys shirk the presumption of innocence. It is Karen McDonald and her Gestapo had an entire police force, the FBI, the ATF, all of the government apparatus, millions and billions of dollars behind her. What Muriel Lehman and Shannon Smith had was the presumption of innocence and the limited resources of the Crumleys, which was the selling of their house. So what, about $75,000. The balancing effect is the presumption of innocence. And if you don't use that, it's why Tyrone Tucker needs to understand. Although his wife is a wealthy individual, but he also needs to embrace the presumption of innocence. He is presumed innocent. So when you go before the jury, you've got to remind them of that, because that jury should have started every question in that case, in both Crumbley parents' case, from the standpoint of the first test. The first test is they have to presume that it wasn't foreseeable, and the state has to eliminate each and every doubt that it was from that. So they have to eliminate each and every doubt and prove that beyond a reasonable doubt it was a foreseeable outcome, and that when they arrived at that school, it was foreseeable. And to do that, they did not do that. They did not reach that burden by any means. The problem is they just blew right by that, and they jumped right into the gun, into this. But they should have said, listen, you've got to go through here, and that's the first stretch. The state has to prove that. The second thing then is they have to prove beyond a reasonable doubt one of two theories of negligence, whether it was a failure to secure the firearm beyond a reasonable doubt. And the thing is, so what does that look like? I mean, what does that look like in this case? James Crumbley sitting there saying, I put it in an armoire in a case, didn't set the code on it, but I put it in an armoire in a case hidden. I hid the bullets across the way. Okay. What the law says, the law didn't say he had to keep it in a gun case. The law didn't even say he had to put the trigger lock on it. I understand it takes 12 seconds, but guess what? The law didn't require him to do that. And we're not talking about general negligence. We're not talking about everyday negligence. We're not talking about civil negligence. We're talking about gross negligence that rises to the criminal standard of gross negligence. Nothing James Crumbley did in relation to the storage of that gun rose to gross negligence. It just flat out didn't. On the other hand, from a duty of care, again, the duty of care runs through the idea that when they get to the school, would an ordinary person faced with those ordinary circumstances? This is where the egregiousness of this prosecution comes in, because what she's focusing with just a little ordinary care, you see a paper that says, help me. Well, when they saw the guidance of trained professionals, that was Mr. Ejact and for some reason, that counselor, Sean, whatever his last name always escapes me, and that counselor, and they sought their guidance. And we find out now that those two gentlemen come into court and testify, and that they'd entered into a proffer agreement with the prosecution, that the prosecution was considering that what they were doing as criminals and was essentially creating the atmosphere that said it was them, Hopkins, thank you, Ian, that it was either them or the Crumbleys. Okay, well, the jury should have known that, because when those two gentlemen come in and say, we're saying the Crumbleys were the bad guys, and the Crumbleys are saying these guys are the bad guys, because those were both defenses. Because Hopkins and Ejack offered a defense for the parents. Because the question is, would ordinary parents coming into the school relying on these experts who tell them it's okay for their son to go back, who don't jump in and say, no, take him out, absolutely not, he's being suspended. They're saying we were counseling the parents and Ethan Crumbley, who, by the way, the state has held was one of the most devious criminals ever, that he's sitting in the room fooling everyone. He's sitting in the room asking for science homework for the express purpose that he wants to get back and go pull a school and go, do his plan. On top of that, Ejack has the bag in his hand. He has the bag in his hand. Could there ever be a more negligent approach that if you're going to have Karen McDonald standing up before the press saying, man, these people, look at that sheet. There's a Sig Sauer gun on there. There's help me. There's blood. And Ejack has the bag and he doesn't look at it. And he doesn't think that sheet gives him a right to look in that bag and say, son, let me take a look in your bag. He's just sat there for an hour and listened to him being told that he was at a gun range with his mother. He knows he was looking up ammunition the day before. He knows in class he was looking up a violent video about shootings. That was a video game walkthrough, but regardless, it's a violent shooting. He knows from his past experience that in September that he said he wanted his family to go away, right? He knows that he's had problems, and you got that bag in your hand and it feels unusually heavy and you don't look inside of it and you just say, screw it. And then 4 people lose their life and you're walking out with a proffer agreement and you don't think the jury deserves to hear that. The defense, one of the defenses in this case should have been to say, they were relying on the good faith. But the problem is those guys got to stand in front of the jury and say, well, we weren't under a threat of prosecution. We were never told we were going to be prosecuted. We had nothing to do with anything like that. We just came forward because we felt the Crumbleys were neglectful parents. That's not why they came forward. They came forward because they were under investigation, facing the potential of prosecution. And they had their attorneys reach out to the prosecuting attorney's office, and they figured out a creative way that they could essentially get non-prosecution agreements. And that should have been able to be explored. That should have been disclosed. That should have been absolutely brought before the jury. In my opinion, you have a potential Giglio issue here that you could elongate it into that, because what they tried to do was circumvent Giglio by saying, well, a Giglio disclosure would require a prosecution. So they said, well, we'll call it a proffer agreement, a proffer not to use your testimony, wink, wink. And since we like that testimony, we're not going to use it against you. We're not going to prosecute you because you're implicating the Crumbleys. When the real people that should have been on trial was the school, because the parents relied on the school, the students relied on the school, and everybody was relying on the school to keep everybody safe. And the school isn't searching book bags. The school is looking at these things as mental health. The school isn't following their discipline code. And they're sending this kid back to class, and he goes off and does a school shooting, and they go prosecute the parents and vilify the parents. Well, I think both Ejack and Hopkins are both. Yeah, I mean, Ejack probably is more at fault, but absolutely because he had that book bag in his hand. But I think both of those bozos are absolutely very responsible in this case. And it should anger everyone. And we're going to turn around and make the parents responsible. When the school isn't adequately following their protocols to let these parents know what's going on. I mean, they give a message. That's it. It'd be different if the school had a history or a long list of these times where we brought the parents in, we told them about this, we asked them for counseling, and the parents just were, this prosecution would make absolute sense if for months and months and months they were trying to get Ethan Crumbley counseling, and the parents were coming back with excuses and saying, well, we haven't been able to do it. There's this reason, there's that reason. And then all of a sudden Ethan Crumbley pops up with a school with a gun at school and blows everybody away. and the parents in the meantime knowing that there's all this crisis going on and all these things happen. But the parents weren't even aware of the family assignment that he wrote months before, right? They weren't aware, but here they are being prosecuted because they weren't attentive parents. But really the reason why the parents were prosecuted is because it makes for a great political story so that Karen McDonald can go and ride the blood of those children right into the governor's office and take it and make this the political grease she needs to grease the wheels of her political vehicle to go right to the top. And she thinks, I got it, and she's going to ride it all the way up, put the Crumbley parents in prison. I mean, ruin their life, ruin the life. I mean, it's insane. And the sad part is these parents are being drug along. And what are the parents saying at the press conference? They're saying next is the school. Well, I hate to tell them Karen McDonald ain't going after the school officials because believe it, she probably didn't even tell those parents that those guys had agreements. And it explains everything. This case is so disgustingly terrible that it just reeks. It reeks. It's disgusting. It's horrifying. And it just pisses me off. Because this is not what justice looks like. Anyways, let's finish watching this video and hear what James Crumbley's attorney has to say about this, and then we're going to call it a night.
Stand during her trial, which also ended in a guilty verdict.
Of course, I look back after this all happened, and I've asked myself if I would have done anything differently, and I wouldn't have.
Why didn't James take the stand?
He has the right to remain silent, and we decided that he wasn't going to testify. He said all of the things that we felt he could say on the stand in police interviews and on video and everything else, so the jury got to hear from him.
The prosecution stressed throughout the trials that both parents should have known that the shooter was in a mental health crisis.
Can you give us any insight into what that relationship was like between father and son and how he missed this?
They had a great relationship. They spent a lot of time together and they talked a lot. And it was never made an issue to James. There were a number of people who didn't see anything. And I think that as a parent, you just don't see it sometimes. And I think that most parents can relate to that, whether they want to admit it or not.
Since the verdict, news has emerged that a school counselor and the school's dean of students, who were the last administrators to meet with the shooter before his rampage, were given something called proffer letters, so the information they provided to prosecutors would not be used to file charges against them.
Were you ever given any information that there was some protection from prosecution offered to those witnesses?
I don't recall ever receiving anything in writing from the prosecutor's office indicating that there were any protection for any of the school employees.
What do you think about that?
If it's true, I think that they should have told us.
Those proffer agreements are not the same as immunity. Officials from the prosecutor's office say right now there is no plan to charge those school officials because they say the facts don't support criminal charges. While James Crumbley does have the right to appeal, Marielle Lehman says that's not something she would handle. Her main job now will be her efforts during sentencing. While she would not get into the details of what she plans to argue, there's no doubt she will be urging the judge to stay within the guidelines for his sentencing. But there is a possibility the judge will go over the guidelines and give the Crumbleys as many years as she can behind bars. We'll find out on April 9th. They will both parents will be sentenced.
Interesting to hear from her. I've never heard of a proffer agreement.
It's fairly common.
It is.
This could become an issue going forward. So we'll see what happens.
It is common. Okay, it's not an immunity, but
it's not the same thing.
It's just an agreement between the prosecutor and those counselors.
And certain witnesses. It happens often in federal cases too.
Got it.
All right, a lot of valuable insight we wouldn't have had otherwise. Thanks, Heather. Really
Wow.
appreciate it.
Well, earlier today, our own Simon Shaykat sat down with Oakland County Prosecutor Karen McDonald. She talked about the threats James Crumbley allegedly made against her, and that agreement.
All right, so there you have it, guys. The defense attorney says she had no idea, and to me, I think everybody knows this thing stinks. You heard the news anchor saying, "Oh yeah, they're not the same as immunity agreements. But listen, it's protection from prosecution, and we go back to the Giglio case, and to me, a protection against prosecution, that's what it is, and it falls within it. And I think it's an opportunity for a wise appeals attorney to be able to get in here and figure out if there's cases out there. There's got to be some cases out there. I'll try to do I don't have access to all the avenues that a appellate attorney would, but I know how to search cases because of my dad and I doing it together all the time. My dad, anytime I'd have a question, he'd make me go find it. So I know how to find it. And that's why as soon as I heard this, I knew exactly what this dealt with. I said, sounds like a Giglio potential. Now it also deals with, there's also rules that have come out of Giglio that have, or Giglio. I'm not sure. I can't remember how to pronounce it. I want to say, I think my dad pronounced Giglio, but that this eventually elongated out and said that this also requires that if there's misconduct of police, if there's, in other words, the police misconduct files or past misconduct of police officers can come in as a credibility factor when police are testifying, and that's one of the side effects that this has come out with. So. The juror foreman. Oh, did it off camera? Yeah, I believe I had that up there, or did an off camera interview. You mean like, so it wasn't on camera? What was it? Just like a report? I guess reported in a news article, Ian. But to me, I feel like it's on point. I feel like this is a situation where, that was wrong. That should have been disclosed. Karen McDonald, prosecutors like her. They are what's wrong with this country, because you don't solve problems, you don't correct issues, you don't correct crime by breaking the law, right? You don't correct the fact that someone broke a law by going and breaking a law and trying to go after them. That's not what you do. I don't believe that's what you do. I don't think that's right, and I don't think that's the way the way our country should operate. I don't believe that's the way the Constitution allows this country to operate, and I believe it's a due process issue. The right to confront a witness, the right to confront your accuser. The right to have fair evidence when they're withholding something, that's straight up as a due process issue. Because they're withholding evidence that was needed by the defense. The defense should have been made aware of this. That's why I think you could, anyways. But hopefully the Crumbleys can afford a good appellate attorney. They don't have unlimited resources. They're going to be facing a lot of time, up to 15 years in prison. This judge probably is going to throw the book at him, I think. I mean, that's how this case is going. They're wanting to make a big statement. I doubt they're going to get, 3 years or something like that. So to me, I think it's going to be a tough road for the Crumleys ahead, because they've gotten convicted. And I think this is exactly what Karen McDonald wanted, because she figured once she got the convictions, the political courage for an appellate court to overturn this thing, it's not going to be strong, and it's going to take a lot. But I think some of the issues that are present in this case, the landmarkness of the case, the fact that you've got, like I said, you've got several prime time appellate issues. I look forward. I hope I can get a hold of any appeal briefs, because I would love to read them. I think it would be great, and I'd love to see what they come up with. I think the defense will try to argue something like that, or and I hope the judge is more sensible than Karen McDonald, because Karen McDonald, like I said, I think y'all know how I feel about her. So I had promised to get into the Chad Doberman case tonight. We're not going to do that. I'm going to push that to tomorrow, because I was going to do Doberman and the verdict, as I said, the Howard verdict. But then this came up. I found out about all of this, and I said, nope, this is getting pushed in. So tomorrow we will do the Chad Doberman, I think that's how you pronounce it, case, in the fact that his statement got suppressed I don't think it's a big deal. He's going to get convicted regardless. I mean, they have enough evidence on him. They've got his daughter, they've got his wife, they've got people there. I mean, my God, they don't need the confession. But I'm glad. It's actually, many of you might be angered by it. I love it, and I think this judge is great, and I think this is exactly what needed to happen in this case, because it is in the most disturbing cases that we show that justice still prevails, because justice isn't about the outcome. It's about respecting the laws. It's about the fact that these police officers, and in this case, this is a very case that when I first came out with the channel and I was trying to figure out what I was going to be doing here with everything, I was watching not Nancy Grace. I was watching Court TV's coverage, and the anchor Julie Grant was on there saying we need to suspend the presumption of innocence in cases like this, and we need to suspend the right to a trial and just immediately convict in certain cases. And I said, "Are you kidding me? What? No." It is for cases like this that this gentleman still gets to the justice system. He still gets the opportunity to have an attorney. Well, the only defense Ian I could see in that case of that isn't going to be plead guilty and then try to mitigate the sentence, which in this case I believe he's facing the death penalty potentially. And that would be some sort of insanity defense, because I believe he's had some mental problems and things like that. I thought I'd heard that, but that would be the only way I see him defending himself. But we'll see. We'll see what comes up. But tomorrow we will be back at it again with the PM version. Let's jump out of the Justice Cameron since we're done watching. Give me a moment. All right, sorry about that. I had to jump out of there. But we're going to be back at watching that Daniel Howard case. Like I said, my perspective so far on that is the jury got it right. I mean, man, when you hear all the evidence of it now, I think the jury got it right in a lot of regards, and even in the idea that how they said it went down with the second degree unaliving, I think that's compelling. And again, I'm looking forward to validating that verdict. It may have been a compromise, but I think in a case like this, I think you can make the case that obviously he was thinking about doing something he wasn't. There was a lot of fighting going on. There's calls to the police, and then they have a big blowout, and he puts her in a carotid choke. Maybe he's trying to settle her down, and boom, takes her out. Now he's got a problem on his hand. Now she's dead. So what's he do? He stages, he stages it to make it look like she unalived herself, and there we go. So, we'll see what happens here, with him as far as his sentence, because again, the judge has to respect the jury's verdict in the sense that the jury, found that he didn't do this premeditatively. It was done in part of a heat of the moment. He still found there was malice, but that it was formulated in a moment, and he got angry and he got mad and he just goes off, kills her. It wasn't some premeditated situation like the state was trying to allege, where they said they had him dressed in like camo and gloves on and all this stuff. He didn't set out to kill her in that moment. Now in a brief second, he decided to kill her. That's why it was second degree, and it wasn't, say, manslaughter or something like that. That was what they went with. But to me, I think it's a tragic case all around. He's a former police officer, but he seemed to be somebody who had problems. He was suspended from the police force for doing crazy stuff. Seems like a guy that needed to get some help, and maybe his pride got in the way, whatever. Guys like that, they seem to just they don't have the capacity to try to get help with things like that. And then what happens? They lose it. They lose control, and they ruin their life. And now he'll be in, even if he gets 10 years to life, it doesn't mean he gets out in 10 years. It just means in 10 years, he gets to go ask the parole board, can I get out of prison? And I don't think most people don't get out the first go around. So he could spend the rest of his life in prison, whether or not the judge gives him a minimum sentence that, extends for the rest of his life, remains to be seen. But the fact that he's a police officer and stuff, I think that'll play into it. If I'm thinking here, I think he'll get 15 years to life. That's what I think the police officer or that the judge will go. That will take up a majority of what he's got left, but it'll still leave him the ability to ask to be released at some point, and for the parole board to consider that. And he'll obviously be on some form of supervised release. He'll miss out on the golden years of his life, and that's the price he's going to pay for what he did. So anyways, guys, I appreciate you coming along. If you just got in, if you're just checking in here tonight, don't forget to hit the like button on your way out. I appreciate that. Also consider becoming a member. We've got one tier of membership, $4.99 a month, get you everything you ever wanted as far as at the Justice is a Process channel. You're going to get access to members only videos. You're going to get access to the behind the stream when we're watching trials daily, when I'm in studio, and you're going to get access to members only polls. And again, you're going to get access to having input into cases and things we cover. So you're getting emojis, you get all sorts of things that will help really enhance the experience you have here while you're watching trials with me. Anyways, check it out. Tomorrow we'll be back. We're going to cover Doberman. I'll figure out what else we've got. Like I said, even if we don't have something major to cover, I've got a whole slew of videos. I've got interrogations. I've got dash cam footage. I've got all of it, man. We're gonna have some fun up here every night. Tonight is a little late. It's 2:00 in the morning my time, so that's why I'm not going to push too far past. But like I said, see you in the morning. And I'm not giving a time tomorrow morning, but probably sometime between 9 and 10, we'll get back and get started with the rest of day 6. And then we will roll into 7, 8, 9, and 10. And I hope have that knocked out by Thursday, if we can. So anyways, guys, until tomorrow, let justice prevail. And I'll talk to you soon. We're going to go ahead and kick off the go home music. Hit that like button on your way home, and I'll talk to you in a little bit.